Ladies and gentlemen, today's courtroom hearing starts off looking simple, but within seconds, it turns into another bizarre special appearance showdown straight out of the Sovereign Citizen playbook. The defendant, Denise Haydish, isn't just appearing in court to answer questions during an arraignment, according to her. She's appearing as the trustee of the estate. And if that already sounds confusing, buckle up, because this hearing only gets stranger from there. Now here's what makes these cases fascinating. Courts deal with real legal procedures, deadlines, and criminal charges, while sovereign citizen-style arguments often revolve around the belief that there's a separation between a real person and a legal corporate identity created by the government. You'll hear references to special appearances, the estate, and attempts to avoid identifying as the actual defendant. But the problem is, judges across the country have consistently rejected these theories because legally courts still need to establish one basic thing: who is standing in front of them. And watch carefully how patient this magistrate is in the beginning. She repeatedly gives Denise opportunities to cooperate, speak with the defense attorney privately, and simply move through the arraignment process normally. But instead of answering direct questions clearly, Denise keeps circling back to the estate language, creating confusion that slows the hearing down almost immediately. What's also interesting here is the contrast between confidence and preparation. Denise clearly believes she understands the system well enough to challenge it, yet moments later she struggles just trying to enter a Zoom breakout room. That contradiction becomes a major theme throughout this hearing. As the tension builds, the magistrate starts realizing this isn't going to be a routine arraignment anymore. The defense attorney even warns the court that Denise wants to speak, despite being advised not to. And once the interruptions begin, things spiral fast. Questions go unanswered, the court loses control of the flow, and eventually the magistrate is forced to make a decision that completely derails the proceeding. So here's the question for you watching right now. Do you think defendants like this genuinely believe these legal theories work? Or do you think it's a strategy to avoid engaging with the actual charges? Let me know in the comments, because this hearing becomes a perfect example of what happens when courtroom procedure collides with internet legal advice.
All right, Ms. Heidish, I did send you an invitation to join the breakout room. If you go in there.
I don't know, how do I find this? I'm not very high tech.
If you click on join, it should allow you to go in the breakout room.
Oh, join.
We're on the record again in case 25-5400 OM. Ms. Ferrara-Wilbur, did you have an opportunity to speak with Ms. Heidish about this case?
We did have an opportunity to chat briefly in the breakout room. It's my understanding at this time that Ms. Heidish would like to address the court. I've advised her against that, but she would like to address the court at this time.
Okay, thank you for that. All right. Ms. Heidish, I just need to verify your mailing address, please.
At this point, the hearing shifts from awkward to openly chaotic. The defense attorney has already explained that she advised Denise not to address the court directly, which is usually a giant warning sign that things may go sideways. Attorneys know that arraignments are supposed to be straightforward, confirm identity, explain charges, discuss representation, and move the case forward. But Denise immediately goes back into the estate argument instead of cooperating with basic procedural questions. And legally speaking, this is where many sovereign citizen-style arguments collapse in real courtrooms. Courts are not debating philosophical identity theories. They're trying to determine whether the named defendant received notice, understands the proceeding, and can move the case forward. That's why the magistrate keeps asking simple administrative questions like mailing address and phone number. Those questions may sound minor, but they are essential for due process and future court notices. What's really striking here is the patience level from the bench. The magistrate repeatedly gives Denise chances to participate appropriately, even after interruptions begin. But once Denise starts trying to redirect the hearing and question the court instead of responding to questions herself, the judge has to regain control. Courtrooms operate on structure, and without that structure, hearings become impossible to manage. And honestly, you can almost hear the frustration building. The magistrate is trying to conduct a standard arraignment, while Denise keeps treating it like a debate forum. That rarely ends well for defendants. The more someone refuses to cooperate with basic courtroom procedure, the less likely they are to get the opportunity to present their arguments effectively later on. So, what would you do in this situation? If you were the judge, would you continue giving warnings and second chances, or would you shut the hearing down much earlier?
And you will readily receive the mail at that address?
The estate will.
What's a good telephone number for the court?
I'm on it right now.
What was that?
I am on this phone right now.
What is the telephone number for that, please?
248-5.
Thank you. Do you ever use email?
Not usually. I get too much spam.
Okay. All right. The next step in this process, and Ms. Ferraro-Wilbur, so I know you had an opportunity to speak with Ms. Heidish about this. Did she want to waive a formality?
Can I interrupt?
No, it's not your turn to talk. Ms. Ferraro-Wilbur, is there any information regarding how she would like to proceed?
I did speak with Ms. Heidish prior to today. I'm unsure if she would still like to proceed as we've discussed.
Okay. It does appear that there is a little contentiousness. So Ms. Heidish, if you would unmute yourself and answer the questions, please. So today is
I wanted to ask you a few questions. I want to know
this is
when
not
I
the
was
venue for
notified.
this. This is not the venue for you to ask the court questions. You're here for purposes of arraignment. I've muted you because you're not staying on
And just
task.
like that, the hearing completely falls apart. Instead of finishing the arraignment, the magistrate ultimately decides the defendant is not cooperating and reschedules the case for another date. That's an important takeaway here. This hearing did not resolve the underlying legal matter at all. All the interruptions, estate arguments, and refusal to stay focused simply delayed the process. From a legal perspective, the court's response was actually pretty measured. The magistrate didn't hold Denise in contempt, didn't escalate the situation unnecessarily, and still gave her another opportunity to appear and participate properly at the next hearing. But the warning about proper decorum was significant. Courts expect defendants to follow procedure, answer questions directly, and allow hearings to move efficiently. When that doesn't happen, judges can become much less patient in future appearances. This case also highlights a bigger issue we keep seeing online: people consuming legal misinformation and then attempting to use it in real courtrooms without understanding how the judicial system actually works. Terms like special appearance, trustee of the estate, or separating oneself from a legal identity may sound convincing on internet forums, but in actual court proceedings, they almost never produce the results people expect. At the end of the day, the court still needs to address the original case, and delaying the process usually creates more complications instead of fewer. Now the big question becomes, will Denise come back prepared to cooperate next time, or will the next hearing become even more chaotic? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.